Farm Credit Bank of Texas Employment Law Overview for Managers. Managers need to know about employment law in order to prevent violations, recognize situations that raise legal concerns, and know when to consult human resources. Employment law is a patchwork of federal, state, and local laws. Employment law is dynamic. Changing workplace practices pose new legal questions, and a grasp of employment law principles will allow you to make informed judgments in most situations. However, you should be prepared to tolerate some ambiguity. The starting point for understanding employee rights is a legal doctrine known as employment at will. Employment at will holds that in the absence of a contract promising employment for a specified duration, the employment relationship can be severed at any time and for any reason not specifically prohibited by law. Employment at will is the default rule that permits employers to terminate employment without needing to have good reasons for doing so. However, there are numerous exceptions to the at will. Employees have the following rights: non-discrimination and equal employment opportunity, freedom to engage in concerted activity and collective bargaining, terms and conditions of employment that meet minimum standards, protection of fundamental rights, and compensation for certain types of harm. The statutes that prohibit employment discrimination include Title VII of the Civil Rights Act of 1964, the Equal Pay Act, the Age Discrimination in Employment Act, the Pregnancy Discrimination Act, Americans with Disabilities, the 14th Amendment of the U.S. Constitution, and Executive Order 11246. Employment discrimination can be defined as the limitation or denial of employment opportunity based on or related to the protected class characteristics of persons. Protected class characteristics include race, color, sex, national origin, religion, citizenship, age over 40, disability, pregnancy, military service, and genetic information. Other protected classes may be recognized under the laws of some states and cities, but not under federal law. For example, marital status, sexual orientation, gender identity, and tobacco use. Retaliation is prohibited when an employee files a claim, participates in an investigation, or opposes unlawful activity. Our Equal Employment Opportunity Policy is compliant with legal requirements and states that we will recruit, hire, train, and promote persons in all job classifications without regard to race, color, religion, sex, national origin, age, sexual orientation, disability, protected veteran status, or genetic information. It is our goal that all such decisions will be made utilizing objective standards based on the individual's qualifications. Harassment is a form of discrimination. Sexual harassment claims are the most common type, but harassment may affect other protected classes. Sexual harassment is a form of sex discrimination that violates Title VII of the Civil Rights Act of 1964. Sexual harassment includes unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. When this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. Prevention is the best tool to eliminate sexual harassment in the workplace. The bank is firmly committed to a work environment free from all forms of harassment, intimidation, and violence in the workplace. Any form of harassment, including verbal abuse or insinuation, will be treated as a disciplinary matter. If a supervisor is informed of or aware of harassment or a complaint of harassment, they are required to notify human resources so the company can take prompt remedial action to eliminate their harassment. It's important to remember that actual or constructive knowledge of harassment triggers a legal obligation to take prompt actions reasonably calculated to stop the harassment. The Age Discrimination in Employment Act forbids age discrimination against people who are age 40 or older. It does not protect workers under the age of 40. Under the Age Discrimination in Employment Act, it is unlawful to discriminate against a person because of his or her age with respect to any term, condition, or privilege of employment, including hiring, firing, promotion, layoff, compensation, benefits, job assignments, and training. It is not illegal to favor an older worker over a younger one, even if both workers are age 40 or older. The Americans with Disabilities Act prohibits private employers from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other terms, conditions, and privileges of employment. An individual with a disability is a person who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. A qualified employee or applicant with a disability is an individual who, with or without reasonable accommodation, can perform the essential functions of the job in question. If a manager believes that a medical condition is causing a performance or conduct problem, the manager should consult with Human Resources. We will then ask the employee how to solve the problem and if the employee needs a reasonable accommodation. If an accommodation is requested, the manager should consult with Human Resources to discuss the request. The Fair Labor Standards Act establishes a federal minimum wage and requires a premium pay for overtime work. The Fair Labor Standards Act does not require the employee to provide meal periods or breaks. A break is a rest period of short duration from 5 to 20 minutes. Breaks are considered working time. Bona fide meal periods are not considered working time if the employee is completely relieved from duty for 30 minutes or more. If you have questions about travel time for non-exempt employees, please contact Human Resources. Non-exempt employees should record actual hours worked and submit timesheets weekly, and managers should approve timesheets weekly. Family medical leave provides employees with up to 12 weeks of unpaid, job-protected leave. Leave may be taken in a continuous block of time or intermittently. Leave may be taken for a serious health condition, birth or adoption, care for an ill spouse, parent, or child, or for service member family leave. To be eligible, the employee must have worked for the employer for 12 months, worked for at least 1,250 hours over the previous 12 months, and work at a location where at least 50 employees are employed within 75 miles. Even though family medical leave is an unpaid leave, we allow employees to use their accrued sick and vacation time to receive pay while on leave. Employers are obligated to inform employees of their rights and responsibilities regarding family medical leave. If an employee has been absent or will be absent for 3 or more consecutive workdays, even if they have plenty of sick time available, please contact Human Resources so we can determine if we need to provide family medical leave information to the employee. Military Caregiver Leave is a part of the Family and Medical Leave Act. It provides up to 26 weeks of unpaid, job-protected leave to care for a covered service member with a serious injury or illness. The employee must be the spouse, son, daughter, parent, or next of kin of a covered service member with a serious injury or illness. Please contact Human Resources if military caregiver leave is needed. Texas is a right-to-work state. Managers may confuse the terms employment at will and right-to-work state. Just remember, employment at will means an employer may discharge an employee for any reason or no reason, but not for an unlawful reason. Right-to-work state means that you cannot require union membership as a condition of employment. The National Labor Relations Act states that employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. Employers are not allowed to prohibit protected concerted activity, to threaten employees with discharge for engaging in protected concerted activity, to spy on employees' protected concerted activity, or to interrogate employees about their protected concerted activity. Examples of concerted activity include an employee complains to each other about schedule changes, employee discussions about criticisms of the employee's performance by coworkers or management, employee discussions of possible discrimination in the workplace, employee discussions about their pay and benefits. Action can still be considered even if the employees are not bringing the concerns to the attention of management. Employees did not intend to bring the concerns to the attention of management, and employees did not intend to change any of their working conditions. Statements do not lose protection simply because profanity is used. The employee criticizes the employer or its business practices. The employee uses derogatory words to refer to the company or supervisors, or the employee uses words that are offensive to a coworker. Please go to Human Resources before disciplining an employee for activity related to complaining about working conditions, negative social media postings, or any activity related to union organizing. In summary, managers need to know about employment law in order to prevent violations, recognize situations that raise legal concerns, and know when to consult human resources. Employment law is dynamic. Changing workplace practices pose new legal questions. A grasp of employment laws will allow you to make informed judgments in most situations, and be prepared to tolerate some ambiguity. And most importantly, always consult human resources.